Russell Zitch versus Jason Stoffel, case number A16738562C. Counsel, please state your appearances for the record.
Good morning, Your Honor. Shawana Johnson, bar number 12791 for Mr. Zitch, who's present.
Good morning, Your Honor. Joseph Guerin, 6653 for defendants.
And counsel, I noticed that the opposition was filed June 15th, and did you file a reply?
We did, Your Honor,
Yes, they filed a reply.
on the 19th, electronically.
Monday.
And I don't have that.
Your Honor, I'm happy
Did
to
you
give
submit a courtesy copy to the court?
Your Honor, I don't actually know. I'm happy to pass this one off if the court would like it.
My notes to myself is opposition 615, did opposing counsel want to file a reply? I will tell you, I didn't review the reply before court today, so I can continue this a week. Did we get a courtesy copy?
Well, the reply says the same thing as the motion.
Yeah,
I think the issue's pretty straightforward. I could probably summarize the reply in my argument.
that's fine. If you feel comfortable going forward, I mean, I read everything that's been submitted. I pretty much know what I want to do in this case. Here's what I'm going to tell you, just in case you want me to read your reply. I'm inclined, and you may change my mind, but I'm inclined to grant the motion with leave to amend. That's my inclination. That's what the law usually requires. I recognize the arguments that you've made at this point, so that's my inclination. We can go forward today, or I can continue the week. I'll read your reply. Maybe that'll change my mind or your argument today. It's your call whether you want to go forward today or continue this a week.
My preference would be to proceed, but we don't want to mess
Sure.
with the court's schedule. I know that you've undertaken a huge responsibility and probably a brick wall of cases already.
Well, I have read
I don't
everything.
want to be the wrench.
I've read everything you've submitted. I've probably read it several times, quite frankly. So if you are comfortable going forward today, I'm prepared to hear your argument.
Very well, Your Honor. I'd like to proceed.
That's fine.
Your Honor, there's one claim that remains. May I proceed?
Yes, please.
There's one claim that remains. This case was originally filed as a legal malpractice case about a year ago. And the sixth cause of action is the only one that's left, and that's for intentional infliction of emotional distress. The facts that give rise to this case, they arise out of an attorney-client relationship that terminated in April of 2013. We know that under NRS 11.190 E4 that this intentional infliction claim is subject to a 2-year statute of limitations. It wasn't filed until 3 years and a few months after the attorney-client relationship ended. So based on that, it's barred. We've been to the Supreme Court once on this. We filed a petition for writ of mandamus, and the court granted that. And it's important to point out, Your Honor, because the opposition to this motion is basically that there's a continuing harm that somehow circumvents statute of limitations. But the Supreme Court was pretty clear because the same argument was made in relation to legal malpractice claims. They wrote, Zitch has cited no authority, nor have we found any, to support the proposition that an attorney continues to commit malpractice by virtue of denying the previous alleged instance of malpractice. The same reasoning applies here, Your Honor. There is no authority. None's been cited or offered to the court in the opposition to stand for the proposition that somehow there's a continuing tort that arises by a lawyer denying that they've committed malpractice. And based on those allegations and based on the statute, the court should grant our motion to dismiss based on the statute of limitations.
Thank you, counsel.
Thank you.
Thank you, Your Honor, if I may.
Please
Thank you. Counsel has misstated what the argument is on the continuous tort. There is a difference between a continuous breach and a continuous tort. What the Supreme Court ruled on is that be no continuous breach of the attorney-client relationship based on an attorney-client relationship that ended more than 2 years ago. At no point did the Supreme Court actually even touch the argument of a continuous tort, which is different. A continuous tort could be something like a leaky drainage that drips down into a condo on a case that I had, and it continually causes damage, even after the tenant moves out, even after two of the parties are no longer in contract. There's a complete difference, which subjects this not to the 2 years, even if it's subjected to the 2-year statute of limitations, it is continuing in nature, even through Mr. Zitch incurring legal expenses and being put through this. That is exactly what the cases I cited stated. They stated that intentional infliction of emotional distress can exist without a breach of contract claim if the defendants are continuing to do things that harm Mr. Zitch's interests that satisfy intentional infliction of emotional distress, i.e., sleepless nights, stress about the case, money expended out of his pocket. Those are all torts that if Mr. Zitch, under any set of facts, can prove, can establish, his case gets to go forward. And I think Your Honor was spot on that we're at the motion to dismiss phase. I mean, this case has been floundering. Nothing has been substantively addressed. We're at the motion to dismiss phase, any set of facts. And so certainly what Mr. Zitch has put in his complaint is a set of facts, any set of facts that says, I am continuing to suffer to this day because of their malpractice. Yes, their attorney-client relationship ended several years ago. However, I am continuing to suffer. And the case law that I cited says that when you are continuing to suffer, even if you don't have a contract legal malpractice claim, since you absolutely can have a tort, i.e. Intentional infliction of emotional distress claim. That is exactly what the Jones case says. The Jones case says that whether her intentional infliction of emotional distress claim by the slander that those doctors committed in that case, that's separate and apart from the actual malpractice that the doctors committed. And in that case, the Supreme Court said the intentional infliction claim, the tort claim, is not tied to NRS 41 because it's a different type of claim. And so in the same vein, I used it as an analogy to say in this case, if there was a 2-year statute of limitations for all of his other claims, which the Supreme Court has found that there is no continuing breach in this case, the Supreme Court absolutely did not find that there was no continuing tort. The Supreme Court did not touch that. And lastly, Your Honor, I would just say that the issue of whether this was time barred was available to defendants first off. They filed a motion to dismiss, which we argued was denied. They filed a motion for consideration and a motion for stay, denied. They filed their writ. It was eventually granted. This argument about the statute of limitations, I would argue, is waived. It should have been brought in the original motion to dismiss. They didn't. So the defendant can't get a full go-round to the Nevada Supreme Court and then come back and say, oh, yeah, we have a different argument. That's waived. So we're asking that Your Honor allow this case to go forward on the complaint as filed, but if not, we would, obviously appreciate the opportunity to amend.
That raised an interesting point, counsel. Under Rule 12, you're required to include all your arguments at that time, whether it be Rule 12b-5, Rule 12h, Rule everything. Did you include this argument initially in your was it a Rule 12b-5 motion you filed initially?
Your Honor, we filed the original motion arguing statute of limitations, and we cited to the Stoffel and Judge case for the proposition that any claims that arise out of an attorney-client relationship are subject to 11-207, which is the statute of limitations for legal malpractice. And that issue was rejected by the Supreme Court, and we're back here on that.
My question is, did you raise the intentional infliction of emotional distress statute of limitations issue in your original 12b-5?
We did, Your Honor.
You did?
Under 11.207.
So you raised it under a different statute of limitations, but you did raise it? Okay. Did you understand my concern?
Yes, I do, Your Honor.
Okay. All right. I'm sorry, counsel. Go forward.
I'll just speak to this continuing breach theory. There's no case law cited to support that there's any kind of continuing breach for an intentional infliction. The facts that are alleged in the complaint, they focus on things that happened as a part of the attorney-client relationship. And there's no statement of anything that is extreme or outrageous that was done after it was terminated. So we have to look at the facts that existed in April of 2013. And the fact that we may have sleepless nights that continue after April of 2013, that doesn't toll or extend the statute of limitations. That'd be like arguing I was in a car accident 8 years ago and my back still hurts me, so my statute is now 8 years because I've decided that it hurts me so much I'm going to sue. You can't sit back and wait. The statute of limitations is clear. It's 2 years. So we'd ask that the court grant the motion.
I agree with counsel that the order from the appellate court regarding your writ is not the law of the case as to the issue, as to the arguments you presented. In the order, the Nevada Supreme Court states, however, we agree with Zitch that his sixth claim for intentional infliction of emotional distress is not premised on duties arising from an attorney-client relationship and is therefore not time-barred by NRS 11.207. Accordingly, petitioner's request for writ relief is denied with respect to this claim. And then it references you to footnote 2. Because the only issue presented in this writ petition is whether Zitch's claim are time-barred by NRS 11.207, we do not consider whether this claim may otherwise be viable. So I do think your motion was properly presented to the court. I do not believe that that was the law of the case precluding you from presenting this issue. And I do agree with you that it is a 2-year statute of limitations. In Woods versus Kings Road Trailer Park, it's an unpublished opinion, 2015 WL 2329-289. It was an order affirming and reversing in part and remanding. The Nevada Supreme Court did say as to intentional infliction of emotional distress, the statute of limitations on these claims is 2 years, referencing NRS 11.190 paren 4 paren C, and also citing Lund v. 8th Judicial District Court, 127 Nevada Reports, Note 6. It's a 2011 case. So I do agree it's a 2-year statute of limitations. So then the issue becomes under 12b-5 whether I should grant this. Counsel's main argument in her papers was this was a continuing tort. In her papers, she cites William versus University Medical Center of Southern Nevada. Again, an unpublished opinion, 2010 Westlaw 3001707. As to the continuing tort issue, the court states, when a tort involves continuing wrongful conduct, the statute of limitations does not begin to run until the conduct ends. Citing Flowers v. Carville, 310 Fed 3rd 1118 at page 1126, 9th Circuit, 2002. A continuing tort exists when no single incident fairly or realistically can be identified as a cause of significant harm to the plaintiff. A continuing violation occasioned by continual unlawful acts, not by continued ill effects from the original violation. So that is what a continuing tort is, counsel. And this is cited from your own case. In your complaint, in reviewing it, I looked for the last date that you cite as something occurring. On paragraph 35, it says, hence, with the State Bar's March 1, 2016 letter, Mr. Zitch has exhausted all of his administrative remedies to hold defendants accountable for their mistake. He could not have reasonably exercised his district court rights until the State Bar's investigation process was complete, for he still had the opportunity to recover for his damages, and as he had exercised due diligence in attempting to discover all the relevant facts and circumstances of defendant's malpractice. In paragraph 36, you state, thus the defense continue instances of harm to Mr. Zitch. With the State Bar's final adjudication on March 1, 2016, Mr. Zitch's current complaint is well within the statute of limitations for his malpractice action. I would note that you filed your complaint on June 16, 2016. In your sixth claim for relief, you state at paragraph 85, defendants have taken no responsibility for their actions and have continued to engage in a general pattern of evasive and unprofessional conduct towards Mr. Zitch, even though Mr. Zitch paid them thousands of dollars to represent his interests. Now, the case that you cited to me also speaks of equitable tolling, things of that nature. Even if I accept all your factual allegations as true, there's no factual allegations in there beyond March of 2016. So on its face, it looks like you have a statute of limitations problem. So what, again, you need to put some factual statement in there. I don't know, what it would be, but you have to put some factual statement that I'll accept as true if Mr. Zitch files another 12B5 motion, which in all probability he will. But I'm giving you this opportunity to amend your complaint. If otherwise you're out of court. So if you are going to argue continuing tort, you need to put factual allegations that support that. You have a conclusionary statement in your sixth claim for relief, which I couldn't find any support for, factual allegations. So I'm going to grant the motion to dismiss with leave to amend. You have 10 days to file an amended complaint. Is that going to be sufficient time?
It will be, Your Honor.
And at this point, counsel, I am going to deny your motion for attorney's fees. I do realize you sent out your Rule 11 letter requesting that she voluntarily dismiss, but in light of my ruling today, I'm not going to grant attorney's fees.
Your Honor, would the attorney fee denial be without prejudice?
Without prejudice.
Thank you. We'll prepare an order right by counsel.
I appreciate that. Thank you.
Thank you, Your Honor.